Hello, and thank you for participating in our guardianship orientation. My name is Samantha, and I am a staff attorney at Neighborhood Legal Services of Los Angeles County, and I work a part of our self-help team. If you are viewing this video, likely you've come to us for some kind of assistance as a self-represented litigant trying to navigate your legal guardianship case in probate court. This video is provided as a general introduction and a brief overview on what it means to be a guardian and kind of the steps and things to consider on how to make it happen. Following this video, we'll give you some options on choosing either our assistance or choosing to work on your own, but we will provide our contact information and other resource materials so you can carry on the case however you'd like to. So let's get started. So first off, I think it's important to distinguish what a guardian exactly is. And so a legal guardian is going to be a non-parent caregiver who has assumed legal custody and physical custody of a child, and this is done through a court order. And so a non-parent is going to be defined as either biological or legal, depending on the circumstances. Sometimes parents will get their parental rights terminated by a court order, in which case, because they are not the legal parent anymore, they can come in and file for a legal guardianship if there are circumstances that will require them to. But typically, a guardian is going to be a non-parent, and that includes non-biological and non-legal. So sometimes people also come to us with a notarized letter or a power of attorney, and they will say that they have guardianship because the word guardian or guardianship is used in those forms. This is not going to be any kind of legal custody that will grant you certain legal rights, and we'll talk about that a little later. This is just going to have your foot in the door and serve as a nomination so you can let the court know that a parent is supporting this decision for you to become the guardian. A guardian is going to step into the role of the parent. So in order for that to happen, the parents themselves have to step out of that role. And so some people will come to us asking to become a guardian along with a parent, and they could be co-guardians of the child. But this would not be granted in a court since the parent is going to be the one practicing any custody. So if you are having that situation and you want this type of arrangement, you might want to consider the other alternatives, and we'll talk about alternatives a little later on in the slides. But maybe a guardianship is not going to work out for you if a parent is going to be involved and the parent is going to be doing some caregiving or all caregiving. A guardianship is also going to be temporary, or it can last until the child is 18. So typically when you file for a guardianship, you will file for a full guardianship under an assumption that it's going to last on a longer term basis. And this guardianship will last until the child is 18, or you can end it prematurely or a little bit early, either under certain circumstances or with specific filings trying to terminate the guardianship. So it doesn't last forever, so it's not a really set in stone option for you. So if you're worried about the longevity of this guardianship, you can always come back and ask the court to either terminate it or to change certain arrangements, to change guardians if it's not working out for you. But just know that as a guardian that's been appointed by the court, it is your legal duty to find alternative options if you're deciding that you're no longer able to care for the child. So why would you need a legal guardianship? Typically, if you're already coming to us, you've already run into some kind of road bump that is requiring you to get legal custody of the child. And so that's exactly what a legal guardianship will do. It'll allow you to have legal and physical custody, so you can go on and make decisions for a child as a parent would. So this list is provided here. It's not an exhaustive list, and definitely legal guardianship will allow you to do a lot more things, but these are kind of the most common issues that we see people running into that will require them to file with us. This includes establishing a new school district and changing child schools, authorizing any kind of medical, dental, or mental health care, participating in educational matters with the child, so this includes authorizing an IEP, obtaining legal documents or receiving public benefits for the child. You'll need legal custody for those things. And some people come to us and they need legal custody to add their child onto their lease or add the child onto their employer-provided insurance or just get Medi-Cal insurance for the child. And so you'll need legal custody to start that paperwork or at least proceed further along. In some cases, when there's an emergency, certain places will allow you to get your foot in the door, but to do anything on a long-term basis, they might require you to come back and get a legal guardianship. And finally, the last consideration for a legal guardian is just ensuring that the child can stay in your care without other parents or third parties getting involved and jeopardizing either where the child is staying or the safety of the child. So there are some things that I like to talk to litigants about so that they can consider it before becoming a guardian. And these are usually things that people come back to us for later on and issues that they'll run into once the guardianship is granted that they just didn't consider when they were filing. So as a guardian, you are stepping into that parental role, so you're financially and legally responsible for the child. Some people end up having issues with the child in regards to troublemaking, and they're unable to take care of the child anymore. And they don't have really any other options. But as their legal guardian at that point, it is their responsibility to find someone else to step into that role. And that might be incredibly difficult considering certain circumstances revolving around the child. So consider just in case the guardianship might not work out, what your other options are so you can try to file for some alternative that will work better for you and for the child's best interests. You will need to locate and serve many parties with notice of your case and with notice of the hearings for this case. So the guardianship will involve you to will require you to involve the parents, the grandparents on both sides, any siblings over the age of 12. You will need to serve or get consent from the child if they're over the age of 12, and you will need to serve the Department of Children and Family Services, DCFS. In some situations, if you're a non-parent or a non-relative caregiver, you will need to involve the Department of Public and Social Services, DPSS, as well. And so you'll need to serve all of those parties with notice before the hearings even happen so that they might attend. And there is a risk of them coming in and objecting to the guardianship as well. So please consider that before getting your case started, because the court's going to require you to take a lot of steps if you want to ask for any excuse of notice or to proceed on with your case without locating and serving these parties. So another thing to consider is an ability to take on another child or other children into your home. So some people will take the child in on an emergency basis and not understand the type of impact it'll create on their already established family in their home. In some cases, if there are circumstances that require a legal guardianship so that it's necessary and convenient and in the best interest of the child or children, a judge might not grant to terminate the guardianship. It might not grant to end the guardianship and give it to the give custody back to the parents because some circumstances happen. So even if you just think it's a temporary or you have a timeline on it, it might not get granted in the future for you to end the guardianship for any reason. And you might want to consider having this child in your home long term, just on the possibility that the child might need to be court ordered in your care long term. You will also be involved with the court until the guardianship ends. So number one, throughout the process of your case, and it's not included here on the slide, but you will need to undergo an investigation. Usually this is done by a court investigator, but sometimes this will involve DCFS getting involved and doing the investigation as well. With all guardianship cases, you also trigger DCFS involvement, and if they decide that circumstances require a case to be opened with DCFS, the case will then be moved, and you won't be able to continue what you did with us, with our assistance, or through Superior Court, and you'll need to go to a different court for that. Once you get a guardianship, and all of the proceedings really end, you still need to check in with the court on an annual basis and do some filings before your annual check-ins to let the court know what's going on with the well-being of the child or children. You also have to ask permission from the judge to move out of state. So a lot of people don't understand that this is something you'll have to do. They think they just have custody and so they can make those decisions. But the judge will want to sign off on the guardianship going to a different state, will want to know where the child is going to be. And then once you take that guardianship to another state, you might need to refile again or register your court order with your California court order with the state that you ended up moving to. And then you might need subsequent filings, or other parties might get involved and file some things going forward. So that's going to bring you back into court again. One thing I like to note is that with co-guardians, decisions need to be made jointly because you are sharing custody of this child with two guardians. So any disagreements that co-guardians will have will need to get finally decided by a judge if they can't come to an agreement on their own. And then you also run the risk of a parent or the minor themselves getting involved to terminate the guardianship. You might get interested parties coming in to file for visitation of the guardianship. And you might also get counter filings so other people can become guardian instead of you. So consider all of these options, especially understanding what your own circumstances are and whether or not these will be issues in the future. So as I mentioned before, there are alternatives to a guardianship. These forms are not going to be legally, will not grant you any legal custody. They will give you some kind of temporary relief, some kind of temporary access to certain things you might need, but they're not going to be long-term permanent solutions for custody of the child. So if you are having the child in your care on a temporary basis, these might be able to get yourself along if you know the timeline exactly. For people that think it's temporary, but it might be long-term, we usually just suggest that a legal guardianship might be their best option because it might go on until the child is no longer a minor anymore. So alternatives to guardianship, this is a caregiver's affidavit. The caregiver's affidavit is just a form that you sign and you provide a little bit of information about the child, yourself, and maybe some parents. But it's not anything you'll file with the court. You will sign it and present it to schools or to doctors, and it will only allow you to get some school-related care done and some school-related medical care done. Places have an option of whether or not to accept it, and there's really no surefire way to know whether or not they will accept it. So this one is the riskiest option, and it might not even work for some places that you take it to. There is also a child care authorization form. This is similar to the caregiver's affidavit, but it will outline certain care that a non-parent caregiver can give a child. The parent will also have to sign this form as well, and they will present it to any schools or health professionals related to the type of childcare they were authorized to give. The power of attorney is similar to that as well, where the parent outlines exactly what kind of power they want to give a non-parent caregiver. It's revocable at any time by the parent, so it's also not a long-term solution. And you will need to get this notarized as well. You can also get a notarized letter that states, just as I mentioned before, it might state that you have temporary guardianship. This is also not a legal custody option, even though it mentions the word guardianship, but it will get your foot in the door. A lot of places will take this, especially if it grants specific powers for you and it has specific pieces of information provided by the parent to give to the non-parent caregiver. And so sometimes this will work. A lot of the times a notarized letter just isn't going to do what you need to get done. So, what does it take to become a guardian? First, you must file a petition for appointment of a legal guardian, and this will be done in Superior Court. Probate ends up taking it in LA County, so please note that the only two courthouses in LA County that will hear a guardianship is going to be Antelope Valley in Lancaster and downtown Stanley Mosque in downtown LA. So consider whether or not you can make it to those hearings, make it to those courthouses in general to be able to carry on your case. After you get your case started, you'll get a case number, hearing dates, sometimes multiple dates, depending on what you're filing. And so you're going to need to serve all of the interested parties that the court might require you to do. So as I mentioned before, parents, grandparents on both sides, siblings over the age of 12. If the child's over the age of 12, you'll need to serve or get consent from the child. You need to serve DCFS. With non-relative caregivers, you serve DPSS, the Department of Public and Social Services. And then there might be extra people that might have court-ordered custody or visitation with the child, even though they might not be a parent or a legal parent or a biological parent. And so you might need to serve them as well. And then additionally, if there is any Native American ancestry, you're going to need to do an inquiry with each of the tribes that might be involved and see whether or not the child qualifies under the federal law that will require you to serve them. And then you might need to serve them and wait for them to get involved in the case. With a Native American tribe getting involved, it's a little bit more complicated and it might prolong your case even more. There is a little bit of relief for those parties who you cannot locate, you cannot identify. You can ask to excuse notice, but the court's going to require you to do some kind of due diligence and show that you made steps to try to locate them. So this is going to be searching them online, on social media, in the phone book if you still have one, or the website for the phone book, doing certain searches on certain databases and seeing whether or not you can find out where their location is. You might need to go to the last known address, last known employer, and ask questions regarding where these parties are. As I mentioned before, there is an investigation that happens before they grant the long-term guardianship that will last until the child's 18. So you will need to participate in the court investigation. This is usually 1 to 2 interviews done at the courthouse or over the phone, and will require maybe a couple hours of your time and the child's time. And the court investigator will also be reaching out to all of the parties they can get a hold of to collect their information too. As your case moves along and before your hearings, it's really important to keep up with any notes that the judge or the investigators post on your case, just so you're clearing up those outstanding items for them so that they can grant the guardianship. So sometimes these notes are in regards to missing information on forms that they want to require, adding supplemental information that will help them grant this guardianship, or providing notice to those parties as I mentioned above. You might need to keep updated with any objections or subsequent filings after you start your case. And so usually some people might come in and argue for it. And so you'll have to keep an eye on those objections and respond to those objections, depending on what kind of issues they bring up in their filings. And there are filings to be done after each hearing that you have to update your case and update your orders. So just be mindful that there's going to be things that you'll need to do throughout the process. And we can always assist with that if you get our assistance, or if you want our assistance, or if you want to do it on your own, but you just have some questions, please reach out to us for those extra steps. And finally, just note that you'll need to attend the hearings. Some people get co-guardians involved, and the co-guardians won't be able to attend, so that might be an issue with the court. And sometimes the court might require you to bring the children to your hearings as well. It is actually a preference that the children do attend so they can participate. So be mindful of that and your schedule and the children's schedule going forward. So how to get the process started. So as I mentioned, we can assist with all of these issues. We can help you get your guardianship form started, and we can help you throughout your case as you're petitioning to become a child's guardian or a children's guardian. You will need to complete an intake, and so after this video, please click on the option to get our assistance, and it'll link you to our intake, and we will contact you soon after receiving your intake. Please note that with our assistance, we cannot provide you with any legal advice or legal representation. We can assist you with completing your forms, answer general legal questions, and provide more information on the process. But we cannot represent you at your hearing. We are not your attorney. So please, if you think that you need an attorney in your case, reach out to us and we might be able to refer you to someone that could help, either on a free or low cost basis or a private paid attorney. You can also file on your own. If you continue on and choose the option to file on your own, you will have access to our forms, our how-to guides on how to start the process, and various steps along the way. Or you can go on the online guide and file system to file on your own, and that will also be linked here as well. And finally, you can hire an attorney. Continue on to choose I want legal advice, because sometimes your case might require you to have a little bit extra involvement or a little bit extra strategy so that you can obtain the guardianship that you want. We will have referrals following that choice if you want legal advice, and you can just reach out to those places and ask any general questions. And ultimately, if you decide that you don't need an attorney, if after talking to attorneys you don't need that extra assistance, come back to us so that we can help you with your case. But if you want to choose these options, there are free consultations, so I suggest try to ask all of your legal questions that might require some kind of strategy, might require some kind of extra knowledge that we wouldn't be able to provide in terms of advice going through with your case. And if you want our help or have any questions, generally these are our numbers and our emails. Excuse the typo on email. You can call 818-485-0571, or you can fill out the intake following this video or provide any information to us. You can also email us generally if it's just a question as well, and you don't need to fill out the whole intake. I hope you found this video a little helpful and to give you a little bit of brief guidance on what to consider before becoming a guardian. And now that you're ready to either become a guardian or go to your next steps, we hope that you do come to us to ask any questions so that we might be able to help you navigate your way through this process or through another process that might work better for you. Thank you so much.